Now, I am going to dictate a legal passage at the rate of 160 words per minute. 5, 4, 3, 2, 1, start. Let's start. This is an appeal preferred by the accused challenging the impugned judgment of the High Court of Karnataka at Bangalore, by which the order of their acquittal passed by the Sessions Court was overturned. The appellants were convicted for the offences punishable under Part 1 of Section 304 and Section 324, read with Section 149 of the Indian Penal Code 1860 within bracket for short IPC. They were sentenced to undergo rigorous imprisonment for 7 years and pay a fine of rupees 5,000 para. The said application is allowed and the cause title stands modified accordingly. Formal amendment to the cause title be carried out accordingly. The appeal stands abated as regards these two appellants: accused number 2, appellant number 2, accused number 3, appellant number 3, accused number 4, appellant number 4, and accused number 6, appellant number 6 have so far undergone incarceration for a period of about 1 year and 2 months para. Mr. S. Nagamuthu, the learned senior counsel appearing for the appellant, submitted that the High Court did not apply its mind to the evidence on record. Moreover, the High Court has not recorded any finding. That only conclusion possible was that the guilt of the accused has been established beyond a reasonable doubt. Without recording any such finding, the High Court has overturned the order of acquittal. Moreover, no specific finding is recorded by the High Court that every accused or any particular accused caused the death of the two deceased persons. He pointed out that there is no finding about the applicability of Section 149 of IPC. He would therefore submit that the impugned judgment cannot be sustained. Moreover, there is a delay in recording FIR para. The learned senior counsel also pointed out that though a grievous injury was suffered by accused number 1, appellant number 1, the prosecution offered no explanation about the said injury. They submitted that in view of the said injury, in fact, a first information report within bracket for short FIR ought to have been registered and an investigation ought to have been carried out to para. In this appeal, we are called upon to consider the legality and validity of the impugned judgment rendered by the High Court while deciding an appeal against the acquittal under Section 378 of the Code of Criminal Procedure 1973 within bracket for short CRPC. The principles which govern the exercise of appellate jurisdiction while dealing with an appeal against acquittal order Section 378 of CRPC can be summarized as follows. Normally, when an appellate court exercises appellate jurisdiction, the duty of the appellate court is to find out whether the verdict which is under challenge is correct or incorrect in law, and on facts the appellate court normally ascertains whether the decision under challenge is legal or illegal para. But while dealing with an appeal against the acquittal, the appellate court cannot examine the impugned judgment only to find out whether the view taken was correct or incorrect. After reappreciating the oral and documentary evidence, the appellate court must first decide whether the trial court's view was a possible view. The appellate court cannot overturn acquittal only on the ground that after reappreciating evidence, it is of the view that the guilt of the accused was established beyond a reasonable doubt para. Only by recording such a conclusion, an order of acquittal cannot be reversed unless the appellate court also concludes that it was the only possible conclusion. Thus, the appellate court must see whether the view taken by the trial court while acquitting an accused can be reasonably taken on the basis of the evidence on record. If the view taken by the trial court is a possible view, the appellate court cannot interfere with the order of acquittal on the ground that another view would have been taken para. There is no other aspect of the matter. In many cases, the learned trial judge who eventually passes the order of acquittal has an occasion to record the oral testimony of all material witnesses. Thus, in such cases, the trial court has the additional advantage of closely observing the prosecution witnesses and their demeanor. Coming back to the facts of the case, after having carefully perused the impugned judgment, we find that there is no discussion about the testimony of eyewitnesses for deciding whether their testimony could be believed. In fact, there are no findings recorded by the High Court after reappreciating the evidence. There is no even a finding to indicate that the High Court considered the question whether the view taken by the trial court was a possible view. Para. Without recording any reason and without recording any finding regarding the role played by the appellants individually and collectively, the High Court has jumped to the conclusion that the guilt of the accused has been established. The judgment does not throw any light on the question who were the authors of the injuries sustained by the deceased and the injured witnesses. There is no finding as to how Section 149 of IPC gets attached. Para. The trial court found that the failure to investigate the cause of injury suffered by the accused, number one, is a serious lacuna in a prosecution case on facts. It is further noted by the trial court that on the basis of prior complaint filed by the accused, number one, appellant number one, alleging commission of assault by PW1, PW2, PW7 and PW12, all of them got anticipatory bail from the competent court. Para. There was a fight over property between the accused and the family of the complainant after in-depth scrutiny of the testimony of the eyewitnesses. For the reasons recorded, the trial court was unable to accept their testimony after having examined the evidence of the material prosecution witnesses and findings of the trial court. We must hold that the conclusions recorded by the trial court were possible. Para. Conclusions which could have been recorded on the basis of the evidence on record. Para. Therefore, the appeal succeeds and we set aside the impute judgment dated 21st September 2010. We direct that unless the appellants are required to be detained in custody in connection with some other case, this shall be forthwith set at liberty. Para. The appeal is accordingly allowed. Stop. Thank you.